My name is Michael Drake. I am the Assistant State Engineer over Adjudication. I work in the State Engineer's Office, also known as the Utah Division of Water Rights. And we're here tonight to talk about water right adjudication for the Navajo Nation Subdivision. And we're excited about this, and we've been working really hard to get to this point, so we're excited that we can do this tonight. All right, so we're going to talk about a few things tonight. We're going to talk about water rights and do an adjudication overview. We're going to talk about the Navajo Nation water rights settlement. We're going to talk about the adjudication process and the timeline, and then we can take questions. And so with that, we'll just kind of get into it. So what is a general stream adjudication? It is an action in state district court, and it joins and binds all water users and the state engineer in a lawsuit to determine water rights. It's all governed by Title 73, Chapter 4, and you can see this map. We've had adjudications underway in every corner of the state. And these have been running since the 1920s. All right, so what's a water right? Many of you are probably very familiar with this. A water right is a right to divert and beneficially use water. And they're defined by nature of use, a priority date, which is when the water right was first placed to use, a quantity of water that's typically described in flow rate or volume, which is acre feet. We use a strange notation for that. A point of diversion, which is the location you take the water from the natural environment, and a place of use, which is where you use the water right. Some typical examples that you might see are wells and head gates or irrigation ditches. That's how you'd know if you have a water right. So why do we conduct general stream or general adjudications? Well, one of the biggest reasons is to bring all claims on the permanent record of the state engineer. And the reason this is important is there's some that are not on the records of the state engineer. One type is a pre-statutory claim, and these are things like diligence claims and underground water claims. So the reason this is important is, the settlement of this area began in the 1800s. Statehood didn't follow until 1896, and it wasn't until 1903 that the very first state water right laws were implemented. And so there's a lot of water development that happened prior to that time. And the state constitution addressed this and in Article 17 and said that all existing rights to the use of the waters of the state for any useful or beneficial purpose are hereby recognized and confirmed. So they're recognized and confirmed, but they're not quantified. And so one of the things we do in the adjudication is we quantify them. There are two key dates there. 1903 is when surface rights were brought on into state water law, and then 1935 is when underground water was brought into state water law. Another big part of bringing all claims onto the permanent record are Federal Reserve rights. And so this finds its foundation in a court case and a doctrine called the Winters Doctrine. And what this states is that when the federal government reserves land from the public domain for a given purpose, it also reserves sufficient water for that purpose. This is elaborated further because water rights are generally a state-based issue, and to quantify these water rights, you need to bring them into the state water rights system. And normally the federal government doesn't like to play nice with the state. And so the McCarran Amendment in 1952 made it so that the federal government can waive their sovereign immunity and participate in these state-based water right adjudications. Federal Reserve rights come in lots of different types. Things like Indian reservations, Forest Service land, Bureau of Land Management, national parks, national monuments are all types of federal reservations that might have water rights, Federal Reserve water rights. Other reasons we do general adjudications is to prevent a multiplicity of suits. Water rights can become very contentious sometimes, and an adjudication condenses this all into one single court case, and hopefully takes care of all of those issues in one court case. While we're adjudicating, we also evaluate water rights for non-use, and so rights that haven't been used or only partially used, we'll evaluate those and potentially recommend those to be forfeited. And then finally, this is the objective that we're all after in an adjudication, is to obtain a final comprehensive decree on all water rights within a respective drainage. And this is important because the state of Utah, in the state of Utah, water is a scarce resource, and so having a full picture is very important to manage that water resource. I think we have a question.
How do you remove and reduce rights that haven't been the forfeited and non-used? Is that does the state engineer have authority to do that, or?
Yeah, so in the state of Utah, the state engineer actually does not have the authority to forfeit water rights, but she can recommend that in an adjudication. And then the court will, she'll make that recommendation. If the court agrees in the process, as the process runs through, and there's no objections to that, then they can be forfeited.
And is it okay, so those are the courts.
Yeah, it's a, yep. Yeah. All right, moving along, let's get right into the core reason we're here is the Navajo Nation water rights settlement. This has been a long time coming. Negotiation began in 2003, and note that word negotiation. The state of Utah has taken the position that we want to negotiate these Federal Reserve water rights. Other states have tried litigation, and it can take a long time and lots of attorneys and lots of attorney fees and uncertain outcomes. And so the state of Utah has negotiated Federal Reserve rights in all cases. In the case of the Navajo Nation Federal Reserve rights, an agreement was reached in 2015. And then in the following years, many people worked to get it ratified. The federal government ratified the agreement in December of 2020, and then in the 2021 session, the state ratified the agreement. And there you can see the two bills that address that. All right, so into the agreement details. What the agreement describes is that the Navajo Nation will have the right to 435 CFS of water, amounting to 81,500 acre-feet of depletion. And this is broken into 4 different blocks, and you can see those blocks on the screen. And each block has a different priority date. These priority dates are associated with the reservation date of those particular blocks of land. And then also part of the agreement is funding for water development projects in the Utah portion of the Navajo Nation. The state of Utah has committed $8 million towards this, and the United States has committed over $200 million for these water development projects. This agreement is a win-win scenario for all the parties. It results in clean drinking water projects for the Navajo Nation. It avoids costly litigation and uncertain outcomes. As I noted, Federal Reserve rights have been litigated in the past, and you never quite know what you're going to get. It also removes a significant unknown from the Colorado River system. And this is particularly important given the Colorado River issues that we have coming up in our state. It also establishes a partnership with the Navajo Nation on the Colorado River. Again, a very important aspect of management of the Colorado River. And it also protects existing state-based water rights. That was an important thing for the state of Utah to make sure that this worked with existing uses. So this is the Navajo Nation Subdivision adjudication boundary. You can see that it very closely aligns with the exterior boundaries of the Navajo Nation, That's by design. We wanted to keep this adjudication very focused on the water rights settlement and incorporating that into Utah water law. So that you'll see it generally follows the San Juan and up to and past Bluff and into Montezuma Creek, and then it goes in and covers the north area of the Navajo Nation. So this adjudication is, I saw someone taking a picture. Go ahead, sorry. I'm happy to go back. The Navajo Nation adjudication is part of a larger state-based water right adjudication. We call it the Southeastern Colorado River Adjudication. And we are presently working down here right now. We published a proposed determination in the Moab area last year, and we plan to publish another one this year within the next couple months. And that's important because it frees up resources that we can dedicate to pursue this adjudication and get it done in a timely fashion. You'll also note that some of the other areas there are unassigned at this time and they're not completed. Areas surrounding Monticello, Blanding, and Bluff being north of the river is not part of the Navajo water right adjudication. We currently don't have plans to we don't have a timeline on when we're doing these areas. They will need to be done at some point, but they're not part of this present adjudication. Okay, real quickly, the water right adjudication process. This is the process that we'll be following, and this is what's elaborated in Utah water law. And you can see on the screen that it is broken into 3 different phases. The first phase is the notice, the summons, and it ends with the notice to file claims. And I'm going to go into a little bit more detail on each one of these. The second phase includes the publishing of a list of unclaimed rights, and then it ends with a final summons and a decree on the list of unclaimed rights. And then the third phase includes the claim evaluation, publishing of a proposed determination, a final public meeting, and then a final decree once all objections have been resolved. So let's go into a little bit more detail on each one of these. Okay, so phase 1 starts with a petition. This is typically not relevant today because all areas in the state of Utah have been petitioned to the courts already. And so not something we need to worry about. So this adjudication began with what we call a notice of commencement. And this was published in the San Juan Record a couple of weeks ago. At the same time, we also published a summons in the local paper. And we also mailed a notice and a summons to all property owners and all water right holders, all known water right holders in the adjudication boundary. So this was a mailed summons, and this is typically something that gets that people get in the mail, and they're worried because it looks exactly like what I describe. It's a summons, and it looks like a legal document. However, if you don't own a water right, this is not something you need to worry about. You don't need to respond to it. But it is a scary document. We understand that. We hold a public meeting, which is actually this current public meeting that we're holding right now. We hold a public meeting at this phase to discuss the adjudication with all the water users and answer any questions they may have. And then this phase ends with what's called the notice to file claims. And at this point, all water right claimants are given 90 days to submit a water user's claim. Now, it's very important at this point, if a water user does not submit a water user claim, they may be prevented from asserting a claim in the future. So it's very important to participate at this point. Let's talk about the water user claim. So every water user that has a water use within the adjudication boundary needs to submit a water user claim either with our office or with the district court. The district court in this case is the Seventh District Court. Now, we understand these claim forms can be very complicated. You see 2 examples on the screen. There's a lot of water rights details there that are sometimes difficult to understand. We're happy to help anyone work through filling that form out. If you are a water right holder of record within this adjudication boundary, you will receive a partially completed water user claim in the mail when we send the notice to file claims. If you don't have a water right, but you are a property owner in the adjudication boundary, you'll receive a blank water user claim rather than a completed water user claim. So in either case, you need to complete the form or review the form and then make sure it's signed and return it to us, the state engineer's office, or the district court. Claims are only required on perfected water rights. Examples of perfected water rights include certificated water rights, decreed water rights, and diligence claims, including underground water claims. What is not, the type of right that does not require a water user claim are applications to appropriate. So a pending application that you still have proof due, you do not need to submit a water user claim on that right. And no one is exempt from this. Municipalities are not exempt from adjudication. Anyone that owns a water right needs to respond to the notice to file claims and file a water user claim. Moving on to phase 2, this is the list of unclaimed rights and the final summons. At this point, we've received all of these water user claims and we've coordinated it and matched it up with known water rights. And so when we find a water right for which we have not received a claim, we put it on a list. And this is the list of unclaimed rights. We give notice to all claimants, all potential claimants. This includes property owners and all water right holders of record. We provide notice and we publish this we file it with a court, and we hold another public meeting. And then once this meeting is to again educate the public about the list of unclaimed rights and make sure they understand what it is and how to get their water right off that list if it is listed. We make a final search of the records for any possible claimants, and we publish a final summons. And there is a period of objection following the filing of the list of unclaimed rights. So if your right was listed on this list incorrectly, you can object and we will remove that water right from the list. Once all objections have been resolved, we petition the court to decree all of those rights, the rights on the list of unclaimed rights, abandoned. And we also petition the court to close the area to subsequent claims. So that completes the second phase. The third phase is where we get into the majority of the work. The division staff evaluates and maps each and every water right, and a state engineer's recommendation is prepared. And this is mailed to the water right holder. Once we've completed the review of all of the water rights, we publish these on the in a document called a proposed determination. And the proposed determination represents a state engineer's recommendation to the court of what each water right should be quantified for. There's a 90-day period to object to this document or the recommendations that are described in that, and we hold a final public meeting at that point. Once we resolve all objections, we petition the court to enter a decree on that proposed determination, and this represents the end of the adjudication process. All right, so now that questions, go ahead. The likelihood of what? That's a little hard to know. If we do our job well, then hopefully there are no objections. That's what I try and do, is make sure that our recommendations are as good as possible and represent sound water right law. And that doesn't mean that people don't disagree, and so sometimes they do. Occasionally they can take a while to resolve, unfortunately, and so we have people that are dedicated to resolving those objections.
Has there been any local opposition to the Navajo Utah water rights program? Or it is possible that there may be?
I'm not aware of any. No. Yeah. Yes, Representative.
So the adjudication area is that area that you identified, and the water rights that we're talking about are just if people have water rights inside the adjudication area, right?
Yes.
So, and you have a friend down there, Hatch, that's got water rights, so he got the letter. Are his water rights in jeopardy? He was actually at our meeting in Minnesota. Was he there?
Yeah. So yeah, the gentleman you referred to does need to file a water user claim once we issue the notice to file claims. Him having a water right, he will receive a partially completed water user claim in the mail at that time. If he agrees with everything there, he will sign that form, return it to us or to the district court. We will come out and evaluate it at some point. If everything's in place, then we write up a recommendation that matches what his water right says it was good for, and we move along.
So that's the one that I'm aware of. I'm assuming there are others.
Yeah.
Is that something that the person in that situation should get an attorney?
They certainly can if they want, right? This ultimately is a court case. Yeah, and I have attorneys, and so that is part of it. Generally, most smaller water users, they don't need to though.
The objective is not to take away something that legally belongs.
Correct. Yeah. Yeah. The state engineer's office is interested in establishing and defining the water rights as they are, and according to Utah water law. That doesn't mean that we don't occasionally recommend a right to be forfeited, and honestly, we view that when that does happen as in the state of Utah's interest. We want to manage these correctly, and if someone is not using it, then we want to get it off the books so that others can use it. We want to give everyone a fair shake, basically, and so it's not an adversarial sort of relationship in an adjudication, although occasionally people might disagree, unfortunately, but we try not to take that approach.
And for any water user, I feel like water in jeopardy, I feel like that's a really strong word. If you're using your water, there's not a problem.
Yeah.
Protect your water is to be, so use your water, and like Mike said, when we come to do our field review, they'll say, oh yeah, it's all in use, and that's how we'll recommend to the court that it be, recommended as is. So you're not in jeopardy unless you're not using it. So, and file a claim. Yeah, and file is important. Everybody has to file.
Yeah.
I know that is common in water, in the water world, and I don't know what the evolution of that policy has been from a property right standpoint. That can be a touchy issue.
It can.
Like, hey, you have something that belongs to you, but you're not using it, so we're just going to take it. And I know that that's not really the situation with water, but it's so close to that, and there's like a line.
Yeah.
And I do worry about somebody who may not be fully, engaged. Grandpa had water rights, and they weren't really aware of what it was, and now they find out that they lost something that could have been really valuable to the family that they just didn't realize.
Yeah.
And I'm assuming through this process, efforts would be made to reach out to them so you know that they've had a fair chance to.
Yeah. And that's part of the reason, and definitely the Navajo Nation adjudication is a unique in the way that the property is held. While there are some private properties within that boundary, most of it is held in trust by the federal government, and so we don't have someone specifically to mail. But it is a concern. How we try and address that is trying to broaden that contact group as much as possible. And that's why we do mail to all property owners and all water right holders to try and capture as many people as possible. And then also including the publications in the newspaper, which I know not many people read the newspaper anymore, but it's there. Hopefully word gets around, and we capture as many people as possible. And there's multiple chances throughout this process to recapture it and to, and to get a claim in, even if it's late. Up to a certain point. I mean, there's a point where, we're beyond the point of going backwards, and we need to have that finality, or else this whole process is not worth going through. So, okay, so the timeline that we're working on here, let's just bring you up to speed on where we are right now. The summons went out on the 16th of March, generally speaking, to and I say that because that's when the mailed summons and the summons in the newspaper was put out. The second part of the summons on this case is to the federal government to enact the McCarran Amendment. That was done on the 24th of March. So what was that, just last week? And so we're fully underway and running on this adjudication. Here we are right now holding the second of 4 public meetings, 2 more of them tomorrow. And so we've completed that. The next step is to sign the conformed agreement. And that's still in the works. We have a lot of busy people that we got to try and get together. It's looking like April or May is when that is possibly going to happen, possibly slipping into June. The notice to file claims is the next big step after this public meeting. The general notice, and by general notice I mean everyone except for the federal government, will go out on May 3rd. We're working on exactly when to do the federal government. It may happen on the same day, but that's what we're looking at. So that's about a month from these public meetings. And then the claim evaluation period is the next part that we will get into. The state of Utah will evaluate all of the state-based rights that we receive. Simultaneously, the federal government, the federal team is going to prepare a hydrographic survey within the Navajo Nation to characterize all of the existing uses of water on Navajo Nation land, because it's these uses that will be counted as part of the 81,500 acre-feet of water. And so they'll prepare that and work with us to make sure we get those uses characterized. And let's see, so, and then we're projecting that we can have a proposed determination completed by the end of next year. There's a lot of work that's got to be done, particularly with the federal team that needs to survey all those water uses. And then we'll look towards the objection resolution and decree following that. So I tried to anticipate a few of the questions. These questions can maybe stir and prompt some additional questions, and so we'll kind of run through these. And if you have any questions, go ahead and raise your hand, and we'll talk about it more. Question that I thought we might get is what water development projects are planned. That's not something I know or the state of Utah has any input on. The Navajo Nation is evaluating which projects to pursue, and they ultimately will make those decisions. Another question. I didn't receive a summons. Was I missed? Due to the unique status of the Navajo Nation, it's just a kind of a small group that received these notices according to our normal notice process. That's the water right holders of record and the property owners. And there's relatively few fee title parcels of land within that adjudication boundary. And so everything else that's happening in the Navajo Nation will be accounted for in the summons that is going to be served on or has been served on the federal government. Okay, now pretending I'm a Navajo Nation member. I'm a Navajo Nation member. What is my responsibility in the adjudication? Unless you own a state-based water right, the Department of the Interior and the Navajo Nation will represent you in the adjudication. However, there's no reason that a member of the Navajo Nation couldn't submit a water user claim, and that's just fine. We will take all of the claims and figure out what bucket they go in, whether they go into the Navajo Nation bucket or whether they go into the state-based bucket. So if there's any concern at all, please file a water user claim. Now, stepping into some other shoes. I own water rights in Bluff or Blanding or Monticello. What is my responsibility in the adjudication? Well, unless you own a state-based water right in the adjudication boundary, You do not need to file a water user claim at this time. We're not adjudicating these areas. We're only adjudicating the area that you saw in that map previously. And we will one day come and adjudicate these other areas, but that's not right now. I own a water right outside of the Navajo Nation adjudication boundary. What should I do to prepare? Definitely, if you're not using your water right, return to use those water rights, or if you're underusing, then begin using your water rights. Another thing that is so important is to make sure your water right title is current. So often that's a major struggle we have in an adjudication is trying to figure out who actually owns these water rights. Adjudication does not update title, and so that needs to be done separately. Even if you have updated title, is the address correct? That's another thing that's very important. These are ways that we can contact you and make sure that you get appropriate notice in the adjudication. Okay, will I lose my water right? Well, if you're in the Navajo Nation water rights are not subject to forfeiture. Only water rights within the adjudication boundary are presently being adjudicated, and so those are the only places you'd have to be worried about that. We address some of these forfeiture concerns. It is something that we look at, but we're going to try and approach every situation with fairness, and so hopefully there is little loss of water rights as we move through this area. Okay, and this kind of brings us towards the close. These are some contact. This is my contact information. We also have Mark Stilson's contact information. I neglected to introduce people. Mark Stilson is the regional engineer for this area, and so he has good understanding of the water right issues that we deal with down here. Nick Yeiter is another gentleman that works with me. Unfortunately, he couldn't make it, and so Ryan Broadbent is with me. And then, since I neglected it, Sarah Schechter is our attorney that works with us, and then Cash Stallings works with Mark, and of course the state engineer Teresa Wilhelmsen is here with us tonight. All right, any questions at this point? We can take any questions.